Advocate Sevak Singh welcomes you to YouTube channel Sevak Sihal. Here are the full details regarding the High Courts in India. First of all, we try to know about the 25 High Courts in brief. And after that we will discuss in details. First question is that, how many High Courts are in India? Friends, there are 25 High Courts in the country, 3 having jurisdiction over more than one state. Among the Union Territories Delhi and Union Territories of Jammu and Kashmir and Ladakh have a High Court of their own. Other 5 Union Territories come under the jurisdiction of different state High Courts. Goa, Arunachal Pradesh, Mizoram and Nagaland does not have its own High Court. The High Court of Chhattisgarh is the largest High Court of Asia. Bilaspur is the administrative headquarter of Bilaspur district. The newest High Courts are the Telangana High Court and Andhra Pradesh High Court, established in the year 2019. The High Court of Punjab and Haryana is working since November 1, 1966 in its present form. It is one of the most beautiful High Courts in India. The states of Punjab and Haryana share a common High Court that is in Chandigarh. The northeastern states, Assam, Mizoram, Nagaland, Arunachal Pradesh, also share the same High Court in Guwahati. The High Court is the supreme judicial body in a state. According to Article 214, each state of India shall have a High Court. However, Article 231 also mentions that there can be a common High Court for 2 or more states or for 2 or more states in a union territory. Bombay High Court has jurisdiction over Maharashtra, Dadar and Nagar Haveli, Daman, Diu, and Goa. Kolkata High Court has jurisdiction over West Bengal and Andaman and Nicobar Islands. Madras High Court has jurisdiction over Tamil Nadu and Pondicherry. Guwahati High Court has jurisdiction over Assam, Nagaland, Mizoram, and Arunachal Pradesh. Kerala High Court has jurisdiction over Kerala and Lakshadweep Islands. Punjab and Haryana High Court has jurisdiction over Punjab, Haryana, and Chandigarh. Let's go ahead. Number 1. Allahabad High Court, the biggest High Court of India. Established in 1866, it has jurisdiction over the state of Uttar Pradesh. Number 2. Andhra Pradesh High Court. Established in 1954, it has jurisdiction over the state of Andhra Pradesh. Number 3. Bombay High Court. Established in 1862, it has jurisdiction over the states of Maharashtra and Goa, and the Union Territories of Dadra and Nagar Haveli and Daman and Diu. Number 4. The Calcutta High Court is the oldest High Court in the country, established on the 2nd of July 1862. The Calcutta High Court, the first High Court of the country. Established in 1862, it has jurisdiction over the state of West Bengal and the Union Territory of Andaman and Nicobar Islands. Number 5. Chhattisgarh High Court. Established in 2000, it has jurisdiction over the state of Chhattisgarh. Number 6. Delhi High Court. Established in 1966, it has jurisdiction over the National Capital Territory of Delhi. Number 7. Guwahati High Court. Established in 1948, it has jurisdiction over the states of Assam, Nagaland, Mizoram, and Arunachal Pradesh. Number 8. Gujarat High Court. Established in 1960, it has jurisdiction over the state of Gujarat. Number 9. Himachal Pradesh High Court. Established in 1971, it has jurisdiction over the state of Himachal Pradesh. 10. Jammu and Kashmir High Court. Established in 1928, it has jurisdiction over the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. 11. Jharkhand High Court. Established in 2000, it has jurisdiction over the state of Jharkhand. 12. Karnataka High Court. Established in 1884, it has jurisdiction over the state of Karnataka. 13. Kerala High Court. Established in 1956, it has jurisdiction over the state of Kerala and the Union Territory of Lakshadweep. 14. Madhya Pradesh High Court. Established in 1956, it has jurisdiction over the state of Madhya Pradesh. 15. Madras High Court. Established in 1862, it has jurisdiction over the state of Tamil Nadu and the Union Territory of Puducherry. 16. Manipur High Court. Established in 2013, it has jurisdiction over the state of Manipur. 17. Meghalaya High Court. Established in 2013, it has jurisdiction over the state of Meghalaya. 18. Orissa High Court. Established in 1948, it has jurisdiction over the state of Orissa. 19. Patna High Court. Established in 1916, it has jurisdiction over the state of Bihar. 20. Punjab and Haryana High Court. Established in 1947, it has jurisdiction over the states of Punjab and Haryana, and the Union Territory of Chandigarh. 21. Rajasthan High Court. Established in 1949, it has jurisdiction over the state of Rajasthan. 22. Sikkim High Court. Established in 1975, it has jurisdiction over the state of Sikkim. The Sikkim High Court is the smallest in India. 23. Telangana High Court. Established in 2019, it has jurisdiction over the state of Telangana. 24. Tripura High Court. Established in 2013, it has jurisdiction over the state of Tripura. 25. Uttarakhand High Court. Established in 2000, it has jurisdiction over the state of Uttarakhand. These high courts serve as the principal civil courts of original jurisdiction in their respective states or territories and have the power to hear appeals, revisions, and writ petitions. The High Courts of India are the highest courts of appellate jurisdiction in each state and union territory of India. However, a High Court exercises its original civil and criminal jurisdiction only if the subordinate courts are not authorized by law to try such matters for lack of peculiar territorial jurisdiction. High courts may also enjoy original jurisdiction in certain matters, if so designated specially by the Constitution, a state or union law. The work of most high courts primarily consists of appeals from lower courts and writ petitions in terms of Articles 226 and 227 of the Constitution. Writ jurisdiction is also an original jurisdiction of a high court. Each state is divided into judicial districts presided over by a district and sessions judge. He is known as district judge when he presides over a civil case, and sessions judge when he presides over a criminal case. He is the highest judicial authority below a high court judge. Below him, there are courts of civil jurisdiction, known by different names in different states. Under Article 141 of the Constitution, all courts in India, including high courts, are bounded by the judgments and orders of the Supreme Court of India by precedents. Indian High Courts, pillars of justice. In the vast expanse of India's legal landscape, the high courts stand tall as crucial institutions, dispensing justice and upholding the rule of law. These courts, spread across the length and breadth of the nation, play a pivotal role in safeguarding rights, resolving disputes, and interpreting the law with wisdom and impartiality. This essay provides an overview of the Indian High Courts, delving into their historical evolution, jurisdiction, structure, significance, and challenges. Historical evolution. The genesis of high courts in India can be traced back to the colonial era when the British established the Supreme Courts in Calcutta, Bombay, and Madras in the early 19th century. With the enactment of the Indian High Courts Act, 1861, these courts were reconstituted as high courts, serving as the apex judicial bodies in their respective regions. Post-independence, the Constitution of India, adopted in 1950, provided for the establishment of high courts in various states and territories. Over the years, the number of high courts has grown to meet the evolving needs of India's federal structure, ensuring access to justice for all citizens. Jurisdiction and powers. Each High Court in India is vested with extensive jurisdiction, encompassing civil, criminal, constitutional, and administrative matters within its territorial boundaries. They serve as courts of original jurisdiction, appellate jurisdiction, and possess the power to issue writs under Article 226 of the Constitution, thereby safeguarding fundamental rights. High courts also play a vital role in interpreting statutes, reviewing administrative actions, and settling disputes between states and the central government. Their judgments and orders serve as authoritative precedents, guiding lower courts and shaping the legal landscape of the country. Structure and composition. The structure of Indian High Courts is designed to ensure efficiency, transparency, and accountability. Each High Court is headed by a Chief Justice, appointed by the President of India in consultation with the Chief Justice of India and the Governor of the respective state or union territory. Additionally, High Courts comprise a panel of judges, appointed based on their legal expertise, integrity, and experience. These judges, drawn from diverse backgrounds, collaborate to adjudicate cases impartially and uphold the principles of justice and fairness. Functioning in processes. High courts operate through a well-defined system of procedures and practices aimed at expeditious resolution of cases and delivery of justice. They follow adversarial proceedings, wherein parties present their arguments before the court, and judges render decisions based on legal principles, precedents, and evidence presented. Moreover, high courts possess inherent powers to regulate their proceedings, frame rules of practice, and exercise disciplinary control over advocates practicing before them. Alternative dispute resolution mechanisms such as mediation and arbitration are also encouraged to promote timely resolution of disputes. Significance and impact. The Indian High Courts hold immense significance in the country's legal framework, serving as the guardians of the Constitution and the custodians of justice. Their decisions shape legal doctrine, influence legislative reforms, and uphold the rule of law, ensuring accountability and transparency in governance. Thanks for watching YouTube channel Sevak Sihal.